but Miss Geyser and Miss Wire attempt to kill and wanted to kill the victim. The reports show that she was stabbed 19 times in the body, torso. And was basically left to bleed to death.
It's been nearly a decade since two preteen girls lured their classmate to a Wisconsin park and stabbed her repeatedly, nearly killing her, all to appease a faceless online and fictional character known as Slender Man. Now, nearly 10 years later, one of the former preteens is asking a judge to release her from a psychiatric hospital. Anissa Wire and Morgan Geyser were just 12 years old when they attacked and stabbed their classmate Peyton Lautner 19 times, leaving her for dead. Geyser held the knife and stabbed the victim, while Wire egged her on. She thankfully survived the horrific attack after crawling to a nearby road, flagging down a cyclist passing by, who then called 911. Wire and Geyser told police at the time they stabbed Peyton to earn the right to become Slender Man's servants and protect their families from him. Wire would ultimately plead guilty to attempted second-degree intentional homicide. She was sentenced to a psychiatric facility, but in 2021, she was granted conditional release and ordered to wear a GPS monitor, but the monitor was removed 2 years later in September of 2023. Now in her 20s, Morgan Geyser wants her turn, as she's asking a Wisconsin judge to free her from the psych hospital like Wire. Geyser was back in court this week as her defense attorneys argue for her release. The first witness from the state during the two-day hearing was Dr. Deborah Collins, who has evaluated Geyser since 2014, just months after the stabbing. Dr. Collins said her initial impression of the then 12-year-old was that she was not well and presented as odd.
My initial impressions included that Ms. Geyser was not well psychiatrically, that she had experienced trauma certainly in the commission of the offenses, and that she also presented as quite odd during the 2.5-hour interview I had with her. So her mannerisms were odd, her expressed emotions were inconsistent, sort of incongruous to what had occurred. At one point, she burst into tears when the threat of her Harry Potter friends not being present to her coming back was broached.
Dr. Collins would go on to evaluate Geyser on several occasions since she was first arrested in 2014. She testified at the time of the stabbing, Geyser suffered from unspecified schizophrenia.
What was the mental condition that you diagnosed her as suffering from at that time?
As I recall, the mental condition was unspecified schizophrenia spectrum and other psychotic disorder.
Do you know at what point between June of 2014 and authoring that report in 2016 that you came to a diagnosis of unspecified schizophrenia spectrum?
I do not know precisely. It was a process, though. It wasn't a conclusion arrived at within a day or a month of contact with her, for example.
Did you believe that she still carried that diagnosis at that time? Or was it just that there was a history of it?
I was certain that there was a history of it. I acknowledged in my report the diagnostic conundrum that had been presented by this case in the interim between the 2022 evaluation and present.
And what is that conundrum that was presented?
The conundrum occurred in the fall of 2022 when Ms. Geyser told her treating psychiatrist that she had never heretofore suffered from psychotic symptoms, but rather that she was faking those or mimicking those from others in order to, and that she had begun to do that immediately following the offense in this case, the index offense, and that she had done that to assure that the home in which she was sexually abused by her father repeatedly was one to which she would not be returned, and that she would stay in a mental health institute.
What did you think when you were presented with that information of her indicating she had never experienced psychotic symptoms?
What I acknowledged in my report, again, is that diagnostic conundrum. What I also knew is that in the wake of disclosing that she had never suffered psychotic symptoms, or her perspective in 2022, she underwent a significant treatment change. Withdrawn from her treatment was an antipsychotic medication, and in the wake of that medication change, so in the fall of late 2022, through the time I met with her, she had exhibited no objectively noted recurrence of psychotic symptoms.
Was she offering any explanation, either to you or in any of the records you reviewed at that time, why this underlying offense occurred?
She has maintained that it had to do with the delusional, my word, delusional, or characterization of imperative of becoming a proxy for Slender Man and avoiding her family and her co-defendant's family from being killed.
But wasn't she now claiming that none of that was true, that she didn't really believe that at the time the offense occurred?
No, it's not that she said she didn't believe that. It's that she said that wasn't accompanied by psychotic symptoms. She described it more like a fanciful belief of a 12-year-old who had been from an abusive family.
Geyser petitioned the court for conditional release twice before, but Dr. Collins says she wasn't ready, specifically pointing out one incident where Morgan attempted to commit suicide in 2021.
She made the suicide attempt at night when her roommate was asleep, and it was quite serious. As I recall, she told me that she had broken blood vessels in her eyes, for example. She had exited her room and staff immediately intervened after she attempted suicide.
Was her exiting of her room to try to get help because she couldn't free herself from the cord she had put around her neck?
I believe so.
And staff ultimately had to cut that cord to free it?
I believe so, yes.
And there was some significant injury as a result?
Yes, it's described in the record, and in fact by Ms. Geyser herself, as a serious attempt.
At least between the offense on May 31st of 2014, there had been no attempt to harm anyone until this attempt to harm herself. Is that right?
Not precisely.
Why is that?
There had been other attempts at self-injurious behavior, not suicide, but self-injurious behavior. So previously at the age of 18 or 19, for example, Ms. Geyser had swallowed batteries, for example. I believe she was also known on occasion to scratch or cut. Not serious suicide attempts, but those were other acts of self-injury.
And I think I was a little confused in reading the reports. Maybe you can clear this up. Was there multiple occasions of swallowing batteries or just one?
To my recollection, there was only one.
And that wasn't the only cause for concern. Dr. Collins also testified she made concerning statements during her individual therapy at the state mental hospital.
So the comment she made during an individual therapy session, kind of an emotion-charged individual therapy session in which Ms. Geyser has invested herself. So she's done a lot of work in individual therapy. But the comments that were memorialized in the clinical notes from the session on October 24th included, quote, "How do you think I was able to repeatedly stab my best friend and referring to the co-defendant? Thought she was all the brains. I was pulling her along too. I didn't care. I couldn't care. I've never known how to care." End of quote.
That's something that stood out to you in your review of the records, true?
It stood out. I wasn't sure how to put context to it. So I knew, for example, that that had been said. I acknowledged in my report that that could have been merely emotion-charged comments made in the face or in the context of therapy, which sometimes happens. For anyone who's been in therapy would know. On the other hand, this is quite recent to petitioning for conditional release and suggests, at least in that moment, a callous perception of herself. She later talked with her therapist about that and put that in terms of a question. So she reframed it and said, how could I have cared if I did this to my best friend? But the recency of it relative to her petition for conditional release, the reference to her co-defendant, and to herself, that was a potential red flag, at least for me.
Enough to give you pause as to whether or not she's appropriate to be released at this point?
Enough when taken in the context of the totality of information in this case, not just in isolation.
When asked if Morgan Geyser still presents a significant risk or harm, Dr. Collins said yes. But under cross-examination, Geyser's attorneys offered a different reason as to why the stabbings happened, as they mentioned the sexual abuse Geyser suffered through by her own father.
Tell the court a little bit about that abuse. What is she reported?
She reports that the sexual abuse, was perpetrated by her father, and that it goes back, or it started as early as she was forming memories. She reports that she tried to tell or communicate that to her mother, that there were red flags, but those weren't heeded. She recalled, for example, during one interview with me, that she would resort to sleeping on the floor because she knew her father couldn't get down to the floor and back up. Ostensibly, she said she did it to be near her guinea pigs or pets, but it was really to avoid the sexual abuse. She reports that her father watched her shower. She reports that her father was often, she knows now, under the influence of drugs and alcohol.
Right. And her mother was where?
Often at work.
Not in the home to protect her.
Correct. And compounding it is that when Ms. Geyser told her mother did not either heed what Ms. Geyser told her mother or believe her.
Dr. Collins testified Geyser has made progress over the years, but when asked by Geyser's defense attorney if there would ever be a time she would be ready for release, Dr. Collins said yes, but not right now.
But if it is, if it's granted, and if over the next coming months, call it 2 months, you don't say a number of months in your report, let's call it 2 months, 3 months, 4 months. Over that period of time, if Morgan continues on the track she's on and continues doing the things that you describe here, then you would say it's appropriate for her to be in the community, right?
There will be a point when I anticipate she will be, or believe she will be ready for conditional release in the coming months.
Okay. How many months is that, if you had to estimate? Is it 2?
I don't know.
Let's just assume hypothetically the path that you've seen with Morgan, the positive trajectory you've seen, let's just assume it continues exactly as you've seen. Is 2 more months at Winnebago sufficient?
My best estimate would be 6 to 12 months.
The next psychologist to take the stand was Dr. Brooke Lundbaum, who had evaluated Geyser since 2014, shortly after the stabbing. She also testified about Geyser previously saying she had faked her psychotic symptoms, but that claim didn't line up with years of observation and treatment.
Did you ask Ms. Geyser about her claims that she intentionally manipulated the court and mental health providers into believing that she was NGI in this case?
I did.
And what was Ms. Geyser's response to that?
Well, there was quite a bit of conversation about that because it is inconsistent with the data. So I did, in fact, confront her with various observations and contradictions that have existed across time, including my own observations. She, throughout all of that, again, was insistent that she had essentially faked it. She had told me that she decided, essentially once reaching the age of adulthood, that she felt safe that she would never have to go home to her family home, and that's why she essentially decided to come clean. When I had asked her about, well, how could anybody essentially trust her self-report given this claim that she, for the long term and in a very advanced manner apparently, faked mental illness. How could anyone believe her self-report? She essentially told me, well, I guess you can't. In my report, there's an actual quote, but that just was, well, I guess you can't.
So there's an acknowledgement by Ms. Geyser that credibility is a huge problem here.
Correct. There does seem to be a significant issue with the change in conceptualization and her own way of describing her mental illness that raises significant complications in being able to understand her mental illness in particular, but also being able to understand the trajectory of it, what may result in decline potentially, and how to effectively manage that mental illness. And that's very important given that all indications suggest that her illness was in large part to the index offense, that severe violence, in large part related to the symptoms she was experiencing.
Is planning, safety planning, and thinking about stressors one might encounter on conditional release an important part of an evaluation of whether someone's ready?
It is.
When you asked Ms. Geyser if she thought she might face stressors that could cause her to decompensate, what did she tell you?
She did not believe that she would face stressors that could cause psychiatric decompensation or behavioral decompensation. She, to her credit, was aware that she may face stressors or barriers related to having this index offense on her record and having a level of notoriety because of the high publication of her story.
Does that make Ms. Geyser a danger to the community?
What is very concerning to me is that contradiction of her self-report compared to years worth of data. Thousands upon thousands of pages of mental health records to compare her self-report to. It's inconsistent. It doesn't line up. And so there's a significant concern about the reliability of what she says in her presentation and being able to understand where things actually are within any given moment of time.
Under cross-examination, Dr. Lundbound similarly echoed Dr. Collins's concerns about Geyser being freed on conditional release.
Now, I want to turn to kind of the big elephant in the room here regarding the kind of change in her conception of her psychosis back in 2014 and in the years following. Would you say that that is your biggest concern and what gives you kind of pause to say that she is ready for conditional release or not?
I would say it is a concern. I have several, though, as I document in my report, but it is a significant concern as part of this particular petition.
And fair to say, neither you nor really any of the medical professionals can say for sure, kind of what the truth is in terms of symptoms at the time being feigned or not, right?
Well, so what I can say is this. There is... Her mental health is well documented, very closely observed from 2012 until today. As she was a juvenile, she actually had one-to-one supervision, which led her to be under close microscope, if you will, where staff was in constant communication with her, constant observation of her behavior, her adjustment. Through all of that, for several years, there was consistency in both her self-report as well as with the observations of her, which substantiated the presence of psychosis. That has alleviated, so there's also evidence of when she has taken antipsychotic medications, there was noticeable improvements with that particular treatment. So I would say that the evidence is supportive of a history of psychosis. There's also evidence of anxiety, depression, and post-traumatic stress. There's also her young age, fantasy that can complicate things. There is indication, both by her self-report, but also in the records, of some exaggeration at times of symptoms, potentially to get out of things that maybe she doesn't want to partake in, or to facilitate more comfort for her in the institution.
Although she testified Geyser hasn't thought of the fictional Slender Man for a while, Dr. Lundbound was adamant there are still concerns about her release. Geyser elected not to testify during her hearing. So the only witness called for the defense was Dr. Kenneth Robbins, who testified Geyser had enough treatment at Winnebago.
What's your opinion specifically about Morgan and her petition for conditional release?
My opinion is that this is a appropriate time for her to be conditionally released.
In your report, you said that it's an ideal time for her to be released. Why is it an ideal time right now?
Because Morgan has improved quite dramatically and needs things that the institution can no longer offer. I think she's benefited a great deal by being at Winnebago in many different ways, but I think she's reached the end of what Winnebago is able to help her with. There's no suggestion that she is dangerous at this time. And the kinds of things that Morgan needs, in my view, help with socialization, help with education, help with becoming independent, are things that Winnebago can no longer provide in an effective way.
Okay, so there's no more treatment she can do at Winnebago. There's no more treatment she can do at Winnebago.
So there's more treatment. I think the downside of being at Winnebago is greater than any benefit that she could receive from the treatment that's offered there.
When Geyser's defense attorney asked Dr. Robbins if he believed she faked her symptoms, he said no and didn't think it was possible.
From all the reports you've read or medical records you've read, is there any doctor who truly thinks she faked her symptoms?
I'm not aware of anyone at Winnebago who believes Morgan faked her symptoms.
Well, isn't concern that she was a sophisticated 12-year-old who was trying to come up with fictional inventions in her head to get out of trouble? Is there anybody who endorses that theory?
Yes, I think most everyone who has worked with Morgan has endorsed that theory.
Okay, the theory that she was in her head believing she heard the voices at the time.
Correct.
Is there anybody who believes that she just made it up to escape responsibility?
I'm not aware of anyone who at Winnebago who believes that to be true.
Is it easy or hard to diagnose schizophrenia in a 12-year-old or a pre-adolescent individual?
It's very challenging to try to tease apart what's fantasy versus what's psychosis.
Psychiatrist Dr. Kayla Pope, who works at the state mental hospital where Geyser currently lives, was called to testify by the judge, and she echoed Dr. Robbins' conclusion. It's critical for Morgan Geyser's development to be granted conditional release.
So it has already been identified by the experts. Morgan has already reached the highest level of privileges at Winnebago. She has actively participated in therapy, medication management, and all the treatment rooms that are available. At this point, she has optimized all that is available for Morgan. And as Dr. Robbins pointed out, we have very little ability to provide Morgan with experiences in the community. And I would agree with him that at this juncture, it's critical for her to have those experiences to help her continue with her development and socialization.
If she remains at Winnebago, what impact does that have on the risk assessment as to her dangerousness?
I don't think it would have much impact. I think at this point she is safe to return to the community, and I don't know that there's much more that could be done to make her safer.
Dr. Robbins, in his report and in his testimony, recommended if she is released to a group home to facilitate further acclimation into the community. Has that been, if you have experience with that type of remedy?
I do, Your Honor, and I do think that would be an appropriate placement for her.
During final arguments, the state reaffirmed Geyser isn't ready to be released.
I think their experience in this area is extensive, and their opinions present clear and convincing evidence. Each of them also, Judge, has a great deal of experience with Morgan Geyser. Dr. Collins, presumably because of her expertise, was hired by the defense in this case. Right after the offense happened, she was hired and I believe met with Morgan for the first time sometime around June 4th or 5th, 5 days after the offense actually happened. She knows Morgan better than any of the doctors that have testified. She's had a longer period of time with her. She knew her back then, immediately after the offense occurred, and has had the most contact with her throughout the course of the almost 10 years. Both of these doctors, Judge, drafted lengthy reports that were thorough and detailed. I guess I can't really say that quantity equals quality, but I think when you look at the reports of Lundbaum and Collins, certainly the quantity shows the amount of effort and detail that they've put into writing their reports and that they put into arriving at their conclusions. Certainly, in my opinion, much more so than Dr. Robbins. His report is 6 pages long. It doesn't have the same detail. It doesn't have the same thoroughness. It doesn't have the same recitation of what's gone on at Winnebago with Morgan in terms of treatment and therapy. Their reports, Judge, I submit, are better. They're more well done. And I think the fact that they are that gives them better quality than the report and ultimately a better conclusion than is arrived at by Dr. Robbins.
But the defense argued out of the 4 doctors who testified about Morgan's conditional release, only one was in complete opposition.
And so when I hear the state suggest that it's just Dr. Collins who has significant experience with Morgan, that's not true. Dr. Robbins was involved in this case right out of the gate, just like Dr. Collins. Look at the case history reflects his involvement right away. So he has just as much historical years with Ms. Geyser as Dr. Collins does. And what's significant is that while Dr. Robbins supports release right now, the 2 reports aren't that far apart if we're looking at them closely. Dr. Collins does say today, this moment, Morgan should not be released, in her opinion. But she offers the opinion that it should happen in the coming months. That's the language she used in her report. And whether that's 3 months or 6 months or however many months it is, by giving the green light today for Winnebago to begin the transition process, that's consistent with Dr. Collins' recommendation, that's consistent with Dr. Robbins' recommendation, and it's consistent with what Dr. Pope said. In fact, the only doctor really, truly coming up here maintaining total opposition is Dr. Lundbaum, one of the 4.
When it came time for the judge to render his decision, he noted just how brutal the stabbing was.
It's a brutal attempted murder. And another aspect of the case is that everybody involved, the victim, the 2 assailants, are all 12 years old. They're all kids. But Ms. Geyser and Ms. Hoyer attempt to kill and wanted to kill the victim. The reports show that she was stabbed 19 times in the body, torso. And was basically left to bleed to death. It is fortunate that somebody came by and either saw her or heard her pleas and were able to get the authorities there, the fire department, the paramedics, to save her. Otherwise, she would have died. Now, there's a lot that can be said about that type of situation, but you think first of the effort to stab somebody 19 times. If you read the complaint and go through the history, she's on the ground, the knife is going in 19 times, and it's Ms. Geyser that's wielding the blade. But then she's not dead. But then they leave. And the only consequence of leaving under those conditions is, of course, that she'll bleed to death. If they were able to think through that sophisticated maneuver, that she'd bleed to death and die. And the posited justification for the attempted murder was to appease Slender Man and become one of his disciples. Thus, the defendants, Ms. Geyser and Ms. Hoyer, then had packed up gear, they left and they started to walk up north to a national forest where Slender Man maintained his mansion, and then ultimately they're apprehended later on the freeway. But that's what happened, so we can't forget what happened, the brutality of it, the callousness of it, if you will. Keep in mind that the defendants are young, they're kids, but that's what they did.
The judge also questioned Geyser's credibility into how the stabbing occurred.
The Slender Man situation to her father, and that her father had been sexually abusing her for a number of years, and that this is her way to get out of the family. She knew she wouldn't go back, but that's why she did a lot of these things. Now, we don't know whether that's true or whether the Slender Man situation is true necessarily. There's tremendous background, tremendous factual support, witness support, professional support that the Slender Man rationale for the murder, the attempted murder, was what was presented and was viewed as true and accurate. Ms. Geyser now reports that that's not true and accurate. Then we have the allegations with regard to the father. The father is now deceased. Comment as well, Ms. Geyser is essentially estranged from her mother. It's not clear whether there's been a rapprochement with the mother. It appears there may have been some effort at that. But that's still an issue that's outstanding. So now we have two new developments in the case that affects the diagnosis and really affects the risk assessment, and that is that Ms. Geyser changed what was the basis of the diagnosis and what was going on from schizophrenia, from Slender Man to non-schizophrenia type situation that changed her medication.
While the judge noted Geyser's progress, he ultimately ruled Geyser still presented a risk to herself and the community.
This court is satisfied by evidence that's clear and convincing that Ms. Geyser does pose a significant risk of bodily harm to herself, to others, or of serious property damage for the reasons that I've stated. Now, as she works hard, she continues to do what she's supposed to do, but that doesn't change this risk. Remember that the community is concerned with risk, dangerous risk. The community is concerned to a great extent as well with what happens to Ms. Geyser. But the primary concern in the balancing, and we talked about balancing earlier, in the Randall case, they talk about the balancing that goes on in the court's decision. The ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the equity's interest in personal liberty and as well as autonomy. So that's the balance. But the balance is the public interest in staying away from harmful conduct. Under these circumstances, this court satisfied that the scales tip in favor of the public, and it tips that way by clear and convincing evidence. So in this matter, after hearing all of the credible evidence, which I'm satisfied was very well presented by both the state as well as by the defense, I'm satisfied that the petition should be denied.
The judge ordered Morgan Geyser be remanded back to the Winnebago Health Institute. The victim in this case, Peyton Lautner, did not appear in court for the hearing. However, according to local reports, several of her family members were in court. According to the judge, Morgan Geyser only has to wait 6 months before she can file for conditional release again. Reporting for Law and Crime, I'm Elizabeth Millner.